Good evening. Oh, welcome. I'm really excited to see this many people taking their time out on one of our beautiful fall sunny evenings in Missoula. So thank you very much for coming here tonight. Of course, the first order of business should be to remind everybody to turn off their cell phones, please. And I had mine on for emergency. Now we can turn that off. If you're here tonight, it's because it's clear that you care about children and you care what happens to them in the biggest crisis of perhaps their life, which is when their parents sit them down and tell them they're getting a divorce. This presentation would not be possible. I want to do some thank yous for the groups that have really made this happen. Would not be possible without a lot of help from different people and organizations. First, I'd like to thank the GAL Case group. And they were instrumental in being able to financially support bringing someone here from out of state to present some of the work that she's seen in California and other parts of the country. But GAL Case had the financial wherewithal to help support that. But beyond that, we've had help from the School of Social Work. We have students here that are doing research, and we had students last year doing research. And they also were able to get this lovely facility for us, and we really appreciate that. Other sponsors include the Montana Legal Services, YWCA, Missoula Family Violence Council, Department of Psychology, and the Business and Professional Women. So what brings me here tonight? My name is Betsy Hands. If you don't know me, I'm a legislator, and I serve for House District 99. So in the last session in 2009, I heard from a constituent and I listened to her story, and it reminded me a lot of stories I heard from residents I worked with at Homeward when they went through divorce. Kind of the nightmare that happens when it gets long and drawn out. Divorce is hard. And what we want to remember is we don't want that to we don't want the divorce to become the burden that the children have to bear. And so the collection of stories that I've heard over the last year and that I continue to hear have helped keep me involved to try to bring together as many different points of view to talk about how do we address this issue so that children get out of the divorce without being completely torn apart in their families. Tonight we've invited Kathleen Russell. She's our guest speaker, and she's here to share a film that she produced called Crisis in the Courts. And what it is a collection of stories of people that have gone through divorce in California. So the stories often help shape a little bit of how we understand what's happening in a place that most of us hopefully don't have to spend a lot of time. So I'm pleased to introduce Kathleen. She's been working tirelessly, and it's amazing that we got her here for this day and a half to shape legislative changes in California. She's also traveled nationally, and she's a part of many groups that are working with initiatives around the country. Just a little bit more information so you know who she is, and then I'll let her take over. She runs a strategic public affairs consulting firm and is a co-founder and part-time executive director of the it's been around for several years, Center for Judicial Excellence in Marin County, California. Kathleen and the center advocate for legislative and administrative changes that will better protect children's rights in the judicial system and promote judicial accountability. She also works extensively with news media to expose what she is finding out is a national crisis in family courts. After being in those, being able to talk about this nationally, her organization has received thousands of calls and emails to her organizations from distressed parents and children from across the country and beyond. And just recently, I think it's really exciting to learn that she was tapped actually by the White House advisor on violence against women, Lynn Rosenthal, to organize the first ever White House briefing on the family court crisis this past May. So in that, she met with the staff from the Department of Justice and from Vice President Joe Biden's office, and there was a 90-minute briefing and discussion with protective parents and national experts about potential fixes that could better protect children and their protective parents as they navigate through the difficult child custody battles. So there's so much we can learn from Kathleen and her work at the Center for Judicial Excellence. And I'm pleased to have her introduce her film and then be able to discuss it more in depth after we look at the film that she's going to introduce. Thank you.
Thank you, Betsy, and thank you all for being here and having a warm welcome to me back to Missoula. It's really great to be here. I actually lived here a long time ago, 15 years ago. I left, but was a resident of Missoula for 2.5 years. And definitely a lot has changed, but there's a lot of familiar that has remained the same. It's been really nice to be in your community all day today. As Betsy mentioned, we are based in Marin County, California, and we're going to have a discussion after the film. I think you'll find after you watch the film that it stirs up a lot of emotion for people. And so I want to devote as much time as possible to that conversation with all of you. And I'll also talk to you a little bit about some of the legislative successes that we've achieved, because I know that there's a legislative working group in Missoula right now of professionals who work in the family law system and protective parents and others who are working with Betsy to figure out how you can come up with some legislative ideas to improve on the system here. It is being done around the country. This film that you're going to see tonight was put together in about 2 months' time. We had rented a theater to show the film, so we had a deadline. We busted our butts to do this film quickly, but at the time that we did the film, we thought that the problems that the parents were talking about and the attorneys, we have attorneys interviewed in the film as well, we thought it was just a local problem in our local court. We had no idea that this was a national epidemic, and we put the film, there's a 12-minute version and a 42-minute version, and we have both of those on the table back there for sale if anybody would like to get them afterward. But we put the 12-minute version on YouTube in January of 2008, and it was that move that really opened my eyes, and the floodgates were open, and we started to get calls from all over the country. We've also gotten emails from Ireland, Australia, Spain, England. This is a problem that is international even, and not just national or local. And what you'll find, and I've talked to some of the moms, and I know there's some fathers here tonight as well that have struggled in the family court, and the problems are almost identical in every community that I've been to, and wherever I show this film. And the people that see it online, that call and email, they say, it's as if you were in the courtroom watching my case when I sat and watched your film. So the problems are not unique to any particular court, and it is a challenge that a lot of us nationwide are now working to improve so that our children are, as Betsy said, not carrying the burden of divorce and bearing the brunt of that. So I don't want to delay any longer. I think we'll watch the film, and then I'll come back and we can have some dialogue about it. Thanks.
What families risk when they enter our family court system are loss of their children. They're at risk of losing their property. They're at risk, grave risk, of being bankrupted.
As long as there's money, there's a crowd, and until it's gone, there won't be justice. I met a woman one time years ago, and my daughter was very young, and she told me that she had lost her son. And immediately I thought, oh, something's wrong with her. Maybe she's a drug addict or an alcoholic, or she has emotional problems, or she's unstable.
A mother to have lost custody is an outcast. There must be a real reason why she has lost total custody. And the pain in that I can only explain as a war-torn vet, because you will never get over that the very system that you believed would protect you is just a money-making business.
The abuse, physical abuse, verbally abuse, emotional abuse, financial abuse, start when I got pregnant. And then November 3rd, 1999, he put me on the headlock over a rice cooker. And at that time I said, you know what, I can't do this anymore. It's just too many hits. I can't handle it. So I grabbed the phone and I called 911. Within, I believe, about 3 minutes, two sheriff cars show up, and the sheriff took him to jail. Commissioner Sylvia Shapiro gave me 3 years restraining order against my ex-husband in 15-minute hearing. First custody trial, I submit several photographs of my child. He's bruised, big as a fist size. In the past, when he was a toddler, his private part was burned. How did he get that injury in the private part? I don't know. I don't know then, I don't know now. My son had been exposed to internet anal sex pornography. I report this incident to the court. Nobody listened. Nobody believed me.
When a child alleges sexual abuse specifically, but also lately it's become any kind of abuse, domestic violence or child abuse, and a parent asks the family court for protection from the other parent for that child, often the allegations are considered by the court or ancillary professionals in terms of parental alienation syndrome.
Parental alienation is junk science. Parental alienation was a concept invented by some fellow back east, and his theory was that parents could alienate a child from the other parent. It first got a lot of press or use with respect to abuse cases, and in the criminal context. As a defense, someone charged with abuse would say, I didn't really do this, the other parent made the child say this.
Who do they blame? They blame me. Why? Because I report the incident. So they blame me, I report the incidents. I'm delusional. Court mediator said, you are delusional.
They don't look for evidence of whether or not a crime occurred. They're more concerned with whether or not the child has been brainwashed or coached to believe that a crime occurred to them by a parent bent on ruining the life of their estranged spouse. Now that idea has many different iterations, it has many different names in family law, and it's kind of an idea that has been completely debunked and is laughed at in other contexts, but in family law it holds sway. It's the reigning paradigm. The way that PAS took hold as the reigning paradigm in family courts was that Richard Gardner, who was a psychiatrist, wrote a book called The Parental Alienation Syndrome, and then published it himself through his own publishing company, Cresskill Press, and then sent a copy of it out to each and every family court in America, with an offer that he could do training if they'd like to invite him to train on that. And that set up a whole new career path for him, because after that, he just had the initial investment of the publishing of the book and the mailing it out, and he did family court training for the next 20 years.
There are a number of courts that have not allowed parental alienation syndrome to be entered as evidence because they say it doesn't meet the Kelly-Fry standard or the Daubert standard of evidence. It's very controversial. It's not a diagnosis in the Diagnostic and Statistical Manual. It is a concept. It's a theory. It's not anything that's been proven.
He never said that his theories were based on any research, and when people challenged him, he agreed with them. They were just his personal ideas.
October 11, 2006, the father made a death threat to our minor son in a hospital setting that your mother gonna get killed. My son didn't tell me until dinner time, and I stay calm, I put him to bed. So next day I took my son to the police officer, and the officer took my son inside the office and spoke with him privately. A few minutes he came out and he told me, "Yupa, you stay here. I'm gonna issue you TRO. Judge Smith issued the restraining order right on the spot." In 2003, the American Prosecutors Research Institute identified use of PAS as a deliberate means to obstruct prosecution of abuse cases.
We're seeing through many studies over the last 20 years that only 1 to 7.6% of allegations of child sexual abuse are maliciously fabricated. Unfortunately, judges assume because of parental alienation's popularity that 99% of them are fabricated, when in fact 92% of them are either true or based on a mistake.
The primary group of American prosecutors, all the DAs in the country, have acknowledged that PAS, which is completely unscientific, it's not accepted by legitimate medical or psychological organizations, it's a completely bogus legal defense of child molesters that's being used in family courts across the country.
It's still a big fad in Marin County. And that is a result of the mindset of the mediators, of the evaluators, of the attorneys who are using it. And keep in mind, these attorneys are using it for tactical reasons, not because they believe it's really occurring, because they know the judges will buy it.
The family courts loved the idea. They didn't realize at first that it wasn't based on any research. And they just thought, oh, this is an easy answer. It explains away these horrible cases that we don't want to have to deal with. Because if we think about whether abuse happened or not, we have to deal with evidence, we have to deal with trauma, we have to deal with horrible ideas, and we have to take a stand and say whether or not it happened. If we can simply dismiss it as some vindictive bitch on a rampage to ruin her husband's reputation, then it's easy to just punish the woman and make the whole thing go away.
The court abducted my child without any ground. I have the clean record. I am a licensed nurse. I take care of people, make sure my patients get well. I do teaching. I am a good mother. On the other hand, the father have history of violence. He have more than one restraining orders. The court gave him sole custody and placed me on 2 hours supervised visitation, 2 hours per week. What ground do they have? What evidence and fact do they have? They have nothing. They have nothing. They just wrote something, pulled something up from the thin air.
No evidence was presented to change custody. There was no reason for them to change custody. There was nothing presented that would even carry any weight to change the custody. The most outrageous part is you have a father who has raised these children from the time they were born, and then you take them away from the only stability that they've had, the house they were born into, and where they grew up. My children are no longer doing piano lessons. They're out of their religious training, doing organized sports. All the things that I put them into that will better them as people and serve them down the road have been wiped out. And they're essentially trying to take me completely out of my children's lives.
I went into court with the idea that we were going to bring two sides before a judge and they were going to come up with a reasonable conclusion to whatever, or the issue at hand. And I found out that was 180 degrees from what I was entering into.
The financial incentives are to keep these situations going. There's no financial incentive to settle the case. The judge keeps his job. The evaluators make a ton of money. The attorneys for the minor and the family court attorneys are guaranteed payment for, if the child's 3 years old, for the next 15 years. Because they never settle, these cases never settle.
If a child is placed in unsupervised visitation or full custody with the person that they've identified as the perpetrator of abuse, you know instantly that their protective parent is never going to just walk away and stop fighting for their safety. So there's automatically going to be a need for an evaluation. There's also going to be a need for a special master because it will be a litigious case and there won't be enough time on the court's calendar to deal with it, so they'll refer it to special master or force the parties to stipulate to a special master. Then you will have the special master typically suggesting that each party bring in parenting coaches, parenting coordinators, therapists for each party that will work with that special master. And suddenly, all these evaluators with alienation expertise have this opportunity to make gobs of money.
Nearly 5 years later, I'm still fighting for my children when my children have told everybody involved with this case, we want more time with our father. We love our father. Here are these people that are supposed to be neutral, unbiased people, and they'll come back to the courts and say, well, you know what? The father, he was the one that coached them into saying that.
The fathers who are trying to protect their children are every bit as perplexed and distraught as the mothers, because they're trying to protect their child from a mother who's having a variety of problems. They are labeled with parental alienation syndrome also. They have the court professionals move in exactly the same way.
As a parent, the only thing you want to do is protect your children. And this legal system now has put me in a place where I have no power. They put the power in the hands of the psychologist, the kid's attorney, the evaluator, and your role as a father is reduced, and your kids look up to you for guidance, for leadership. You're their hero, and you're not able to help them. That's a tough position to be in, especially now when you're out of money. I mean, where do you go when you've extinguished all your resources financially, and they've got to a point where you're powerless as a father?
There's a pattern to the cases. What we found is we can finish someone's sentence when they call us. We know what the next step in the pattern is. The abuse allegation arises. The alleged abuser goes to family court with the high-priced and very aggressive attorney. The plethora of people are involved. The money is systematically stripped from the protective parent. At that point, the professionals who are working with the child work together in concert. They even write that they're working in concert. And they all seem to support the alleged abuser. And the custody is then switched.
During the first custody trial, the court mediator failed to follow the local rules and the law. She broke every single rule in the book. She doesn't read the file, she doesn't read the pleading, she doesn't know the history of, my case.
The Family Court Services mediators are supposed to know the law and know the procedures. And they don't. I don't know what they're teaching at the Judicial Council classes, but it sure isn't the law, because they don't know what they're doing.
Mediators only spend a few hours at most with a family. They are not trained to be doing these kinds of investigations. They're trained as mediators to try to bring people into agreement.
You try to work out your issues, and if you don't, the mediator can make a recommendation to the judge about what he or she thinks should be the custodial status of each parent.
Well, that completely thwarts the entire idea of coming together and trying to work out an agreement between two parties.
And the real problem is that mediator ends up deciding your case. And that's not how the system is supposed to work. And so when the mediator decides your case, whoever loses is, quote, disgruntled, and they should be not because of the outcome, but because they never got a trial.
I felt at the time that I agreed to joint custody that I really did not have a choice. I knew that the father would make life very difficult if I didn't agree to joint custody. And I did want to try. It's just that there were so many problems since the moment he found out I was pregnant. So we actually tried a couple of overnights, and she was suffering from a yeast infection that only got worse after the overnights. And shortly after she had an overnight, I took her into Kaiser, and she not only had the yeast infection, but she had vaginal discharge, and she ended up with yeast on her tongue and around her rectum. And I didn't want to believe that anything was going on, but it wouldn't go away. And eventually she started talking about the hole in her vagina. Eventually, when she was old enough to talk. The evaluation basically was to see if there were any problems, these problems that I was reporting to CPS. It took about 6 months to complete this evaluation. The evaluator interviews the child and the parents, and in this case the grandfather as well.
The evaluators are the ones who most frequently recommend that the child be placed with the very person that the child has identified as their abuser.
The first day I met the custody evaluator, I had this overwhelming feeling that she had already sort of made up her mind about this custody evaluation. My daughter began to talk about things that had me very concerned, which I reported to the evaluator. And one evening she took a necklace out of my jewelry box, and right before taking a bath, she was naked on the floor and put my necklace up to her vagina and said that the snake goes into the hole. And on another occasion during the evaluation, we were getting her ready for a bath, and she was sitting on her knees in the bathroom and began to bounce up and down on her knees, and she had a tight fist as if she was holding something. And I said, "Well, what are you doing bouncing?" And she said, "I'm on his lap." And she said, "I have to hold the snake until it dies." And she still had the tight fist as she was bouncing up and down. And at that point, I thought, okay, this is just not making any sense at all. And each time I would I would call the evaluator to let her know what was going on.
The evaluators were all to be trained in child sexual abuse so that they would have better training, they would have more expertise, and they had very specific rules and laws to follow.
Unfortunately, what happened was the same parental alienation trainers who were training court professionals in parental alienation just changed the name of their course to the new child sexual abuse training and trained basically the same misinformation.
After a short time, the evaluator did a home visit at my home and the father's home, and apparently the father and the grandfather, my daughter's father and her grandfather, either went out on their property or went and purchased a snake to make it seem like my daughter had a pet snake the whole time. The evaluator, when I met her next, she said, see, they're just into nature, and this is basically all your imagination. And I said, well, really, tell me when did the father get the snake for my daughter? And she said 2 weeks ago. And I reminded the evaluator that this report was made to my attorney and to CPS 6 weeks prior. So at that point, she got very flustered and very upset and very angry with me, and told me that it was just my imagination, that I was imagining everything.
Many players in the psychological mediation and legal process can become enablers of the abuse. I don't mean purposefully colluding with the abuse. That's a whole area we can also talk about. But inadvertently, almost subconsciously stumbling into becoming a colluder with the abuser. Not understanding that the person being abused is bringing valid information into the courtroom, and that person is being found not credible while so doing. It's terrible what's taking place. It's heartbreaking, it's sad.
The evaluator eventually issued a report, and the report didn't really make sense to me, but basically said that I was a danger to my child and that my child should be taken from me. And given sole custody to the father.
I don't think I have ever seen an evaluation or a mediation report that followed the laws that are on the books and the rules of court. I don't think I've ever seen one, and I've seen quite a few of them. The court orders counseling for the children, and sometimes, and particularly in Marin County, there have been a number of cases in which the counselors are aligned with the abusers and basically spend the counseling time saying how great the abuser is and how awful and crazy the mother is.
Attorneys know who these therapists are. Every county has 2 or 3 or 4 of them. You can go into court, the judges think they're wonderful, only because what do the judges know? They see them all the time. And they go, I think the children need therapy. Well, so the judge says, well, I'm going to order therapy. Can't hurt them. What's wrong with you that you don't want your kids to go to therapy? I'm going to order the kids to go to therapy. We want them to go to Dr. So-and-so. Well, that's fine. I know Dr. So-and-so. He's in here all the time. He's really great with kids. Dr. So-and-so. Now you've got the kids going to Dr. So-and-so. The parent who is recommending Dr. So-and-so is the one who brings the kids to Dr. So-and-so and spends a good amount of the kids' time telling Dr. So-and-so what's wrong with the kids, what the other parent did, and so on and so forth. And then when it comes time for trial, it's Dr. So-and-so who comes in and says, this is what's going on with this family.
What they always say is those are mental health professionals. They know much more about children and what's best for kids than we do. I just make decisions based on facts here. That's my expert. They'll advise me. But there's no oversight as to whether that expert has any expertise in the area of child sexual abuse or child physical abuse or domestic violence.
I have a case where a child was ordered to go to therapy at age 3, and 4 years later, these kids were still going to therapy. This kid had been in therapy longer than it had been alive. This kid didn't have to remember what happened in his childhood and tell the therapist about it. The therapist was there. I mean, this is the level of insanity that goes on, and it's perpetrated by attorneys and by judges. By attorneys for tactical reasons, and by judges because it makes their job easier.
Much of the money comes from the litigants. That's the chilling part of it.
It's a business, It isn't where we're dealing with human people's lives. It's a big business. It's a money-making business that you're having people earning a big living.
This should not be a money-making industry, and we should not have profit linked to representing people who are undergoing this process.
All these people that are making hundreds of thousands, millions of dollars statewide off of the whole family law machine, they want the court to make those orders because those orders are what get them paid, and it's the reason for their existence.
So people in counties like Marin can pay $50,000 or $60,000 for an evaluation.
That's money. That's money buying something we label as truth and justice, where it's not money buying truth or justice. It's money buying, in some cases, lies, really damaging lies with long-term consequences.
There is something very, very unethical going on, at the very least.
They may utilize an expert who they know is going to come up with a result that they want. They're going to use a mediator who they know is going to come up with the result they want. They're going to use a child's attorney who will not investigate, and thereby they'll get the result they want.
And they say, hey, we're going to be working together for many years. You take care of me, I'll take care of you. I'll send all my business your way. And they have a little, the cronyism and the friendship in what goes on, what they actually keep from the courts and what they put in, and what really happens are two totally different things. They will do anything they can to make the ruling go in the way of the person that got them that job or they have that friendship with. There is no, the children's best interest is never even considered. They just do what works best for them, and they keep it in their little group.
It's who you know and how much money you have. It doesn't have anything to do with the law. It doesn't have anything to do with justice.
We recently had, in a cross-examination, one of our mediators talked about how she had talked to minors' counsel, but Family Code Section 216 forbids minors' counsel to talk to the mediator except under very explicit circumstances, and she admitted those circumstances did not exist. But the amazing thing was she was completely unaware of Family Code Section 216 prohibiting her from being able to talk to minors' counsel. She said, we do it all the time here in Marin.
We have mediators in Marin County who flat out lie in their reports and have been caught at it by the appellate court, and the trial courts have been reversed because of it. Oh, they're still working in Marin County and they're still writing reports, still making recommendations.
Marin has one of the more unique reputations in that Karen Winter came and did an investigation into the Marin court, and the information that came out of Marin was just hair-raising, absolutely hair-raising.
Certain names came up in the report, therapists, attorneys for children, and it just so happens that my ex-husband's attorney was mentioned in that report. Also, the attorney for my daughter was mentioned in that report, and the judge that was on our case was mentioned in the Karen Winter report. And at that point, I just felt that there was nothing I could do for my daughter. That if this was going on in the family court, that there was just no way to protect her. I felt like I was at the end of my rope. I couldn't help my daughter. So one day I decided that I had to leave. That I had to leave our home and our family and just take my daughter and protect her. And for 3.5 years, we lived a very different life.
Well, my son had to do this board, and he did. When I went to back to school night, I knew nothing about it because I hadn't spoken with him. And I read it, and it says, meet my hero, and it says, my dad. My dad inspires me to do everything I do Sports is just one of the many things he helps me with. He is always there when I need him. He is my inspiration. It's got my picture in there. You may lose the battle because everybody else will say whatever they want. But in the end, I'm going to be able to look at my children. I'll look them in the eyes and say, you know what? I told the truth from point A to point B. It doesn't necessarily make you the winner in the court, but you're going to be the winner in life.
The complaints about Marin County have gone to all levels, starting with the judges, the presiding judge, the court executive officer, the Commission on Judicial Performance, the Judicial Council, the newspaper. All avenues have been exhausted. So who ultimately is in charge of our courts? It's Chief Justice Ron George. And I think at this point, having watched all avenues be exhausted, I say, Chief Justice Ron George, what are you doing? Why aren't you fixing what's going on in our courts? You know about it. Why aren't you doing anything?
But his reaction was, we're concerned about the public's perception. And when bureaucrats are concerned about the perception of the people they work for, what they're really saying is, it's not my fault. We don't have any shortcomings. We haven't done anything wrong. It's just the way they're seeing us. We have to get, our PR needs work.
I've worked in large bureaucracies all my life. And what I've found is that if the top leadership is competent and ethical, then everyone from that point on down to the janitor is also competent and ethical. If, on the other hand, there's any foul play or corruption or lack of ethics at the top, that too trickles down.
Their credibility is everything. And it isn't about how the public perceives them. It's about reality. And when they start hearing these complaints coming over and over again about the same things, rather than circling the wagons and sending their court administrator out to make some public statement, or their court administrator out to insult somebody with a dismissive, letter to the editor or whatever, that they're a disgruntled litigant or this or that or the other thing, they really need to say, hey, have we got a problem here?
The biggest tragedy in the whole state of California, that when a mother has exhausted all remedies to protect her child through the court system, and she finally does something as dramatic as fleeing with her child when it's clear that the child will be placed or has been placed with a molester or the identified molester, she's hunted. It seems like more effort is put into hunting this mother who's trying to protect her child than in finding criminals who are battering and molesting and raping people.
In 2004, January of 2004, I was arrested. They located us and arrested me. I went to jail, and they took my daughter. And without even assessing her, they gave her back to the father and the grandfather. And I stayed in jail for approximately 5 months. The family court judge at the time called all that evidence, all the information, frivolous. But yet that same evidence was allowed into the criminal court. We had a trial with a jury, and we were able to bring out the evidence regarding my state of mind and the reason why I left, basically. And the jury found that I was innocent, completely innocent. So they acquitted me. I think they really got that the players, the therapists, the attorneys, the judge, CPS, the sheriff's department, and the DA, none of them were really looking out for my daughter. And so I was put in a position to be the one to protect her. Now looking back, I realize it was not the answer to our problems. I would never ever recommend leaving with your child without following a legal procedure. This only made things worse for me and my daughter. Going through the Marin court system has absolutely destroyed my relationship with my daughter and any chance of being a mother to my daughter. And I just hope that they haven't destroyed my daughter.
No one will fix it until the people who are making policy decide to fix it. And they're not going to decide to fix it until pressure is brought to bear on them to fix it. And that pressure has to come from the public, it has to come from the press, it has to come from our elected officials, it has to come from the oversight entities, it has to come from law enforcement.
It is a big, ugly, awful, incredible story that people don't know what to do with that. Just like those big stories that when there was finally a change, it was that there were enough people, or it was made big enough that more people took an interest. Just like global warming, just like the Catholic Church.
The people that I talk to across the United States, they say that each state has its judge, individual rogue judge, or its individual rogue court, or the whole court system is a mess, does not protect children. So it's a national and an international problem.
I would say we're seeing an emergency here. When these children are being damaged, they're treating like throwaway kids. They're disposable. Their welfare is disregarded entirely. The courts should not bear this burden by themselves, nor should any single mediator or profession. It's too serious.
What we believe and what we've suggested to the legislature is to have a multidisciplinary panel look at these cases for a second look to see if the child is safe. You know, I have no other agenda than that.
I think at least 5 different individuals from several different walks of life must review a decision about parental alienation, about child abuse, about custody, about domestic violence, especially when domestic violence exists.
There are many, many Californians who would welcome and cheer a sponsor for a bill who would implement judicial performance evaluations. Enough is enough. We need to have oversight, and we need someone courageous enough to say, look, the Judicial Council, you want your $3.9 billion budget. Okay, but let's implement judicial performance evaluations too, so that we know, as we're funding your requests, we know that your judges are following the law. We know that the public is being served by our courts. We know which courts are problematic, and by the way, what are you doing about it? And that is what judicial performance evaluations would provide. That's responsible government. That's the duty of our elected officials, to make sure that the citizens are protected.
I love him so much. And when I first saw my son, during the ultrasound at 3 months pregnant, and I promised myself that I'm going to be the best mother that I can be. And I don't know how could I love somebody so much, the person whom I never meet, and I love him. And the court had took away my love.
So, I think I want to update you a little bit in terms of the ending of that film. Joe Lazor and Yupa and Jonay, basically they've all exhausted all of their potential legal remedies and none of them have improved. Actually, Joe and Jonay have no additional time with their children. And Yupa has just in the last month gotten unsupervised visits with her son for the first time. And that's after 3 years of supervised. So I know some of the terminology in this film doesn't fit in exactly with the Montana terminology. Mediators here are different than mediators in California, and we call minors counsel what you call GALs or GALs, and so some of the terminology is different, but the dynamics of the appointment process and the ways in which the courts are missing these important cases around domestic violence and child abuse are very much the same. And I know that this is a very heavy film to watch and to process, especially those of you who haven't lived through it, and those of you who have, it probably stirs up a lot of feelings about your own experience. And those of you who work in the court system, I do know that there are good-hearted people who are professional, who care about kids, who are as frustrated about the challenges of these cases as anybody. But there are systemic problems. They're not going away. And we do all need to, as a community, in each of our communities, roll up our sleeves and say, enough is enough. Let's figure out how to protect these kids better. And so just some good news along those lines is that I think Betsy mentioned in the intro, we had our first ever briefing at the White House in May of this year. And the White House is actively looking behind the scenes and trying to figure out ways with funding and other changes to deal with this problem. It is challenging from their point of view because courts are run by the states and it's not a federal jurisdictional issue. But just the fact that they're aware of the problem and that it is systemic, and the Department of Justice has been briefed a number of times now, we're hopeful. And then there are laws and there are changes in bills that are being passed. Just last month in California, the governor signed a bill that we worked on for 2 years that gives children a voice in family court that are 14 years and older. We had wanted that to be for kids 10 and older because in juvenile court, they're given a voice at 10 years, and we thought, well, these children deserve the same right, but our opponents who work as court appointees felt that 14 was the proper age. So there was some compromising and negotiating that went on. You know, baby steps in the right direction. I mean, this is, I think some of you may have seen the Dr. Phil show in April, which I appeared on and worked very closely with the producers to really show the impact of this broken system. And while all of the cases that you all are experiencing and that people around the country are experiencing in terms of children being placed with parents who are harming them are heartbreaking stories. Another new development since this film was made is that we're seeing an epidemic uptick in the number of children being killed by a parent. And in last year alone, we were just documenting through the media cases that involved custody. There were more than 75 children in less than a year, I believe it was an 8-month period, who were killed by their fathers in custody-related issues. And there certainly are also some mothers who've killed their children. And these were almost all preventable cases. You go back to the court records, which we've done some of this research. And in many, many of these cases, the protective parent went to the court with physical evidence. In the case of Katie Tagle, her case was profiled on Dr. Phil, her mentally ill ex-husband or the father of the child, they were never married, but he actually had emails that he had sent describing how he was going to kill their 9-month-old baby. And because of parental alienation and the judge's belief that she was fabricating he didn't even look at the evidence, or he basically dismissed it 10 days after he called her a liar 6 times in a 5-minute hearing and said she was fabricating these death threats. 10 days later, the child was killed by the father, who then killed himself. And I did a press release about this nationally, and within the 2 weeks after that murder, 10 other children in America were killed by their fathers, and about, I think, 7 of those cases involved some sort of custody dispute. So this is a life and death problem in our communities, and unfortunately, I think in America we sort of all believe we have this perfect justice system, and everybody gains a sense of security who isn't in the court, thinking when I go there, I'll present the facts and, you know, the truth will prevail and justice will be served. And it's a very different reality and I'm sure some of you who've lived through, you know, 5, 10, 15-year family court cases, which are incredibly damaging. A lot of women who've suffered through 20-year domestic violence marriages say that they wish they'd never left the abuser, and because their experience in family court is more abusive than it was living with the abuser, because you go to court believing that you'll be protected, as one of the moms in the film said, and to then find out that you're being further harmed is very difficult for a lot of people. But there is progress being made. People are beginning to find each other. Even tomorrow in Washington, D.C., there's a major march from the Department of Justice to the U.S. Senate building. There are parents from around the country gathering and coming together to demand congressional hearings on the broken family court system. In California, we worked for 17 months and got our state auditor to come in and audit what was happening with the court appointees in 2 of the worst counties, Marin County and Sacramento County. So right now the state auditor is looking through files and is talking to the court personnel, because the legislature said, these stories all sound terrible, but they're anecdotes. We need some real data about how many of these kids are being harmed and where are the cases that are going right. And once this audit report comes out, which is due in January of 2011, then it sets the benchmark for future legislation where we can say, all right, here's where the problems are with the court appointees, and let's get some legislation to improve on that. So, you know, there are certainly some success stories, but the nature of this problem, and at least our organization, is we get calls. I get 5 to 10 calls a week from people, and brand new people from all over the country who happen to find our website. When we were on the Dr. Phil show, we were deluged with calls and emails for a week or 2 afterward from many more people. So I wish I had, you know, more hopeful news that we figured out the magic bullet to fix the system, but it's a very big problem and not one that's going to go away overnight. So it's inspiring to me to see that there are a group of people working in the family law system here in Missoula who are coming together with parents who've lived through this system and are saying, let's put our heads together and let's find some common ground and let's figure out how to improve the outcomes for these children. So with that, I think I want to hear from all of you. Comments, questions about the film, or your own experiences around this issue. This is sort of an opportunity to share. Yeah.
Well, I'm just a little curious. In the incident where you had the father killing the 9-month-old child, what was any response from the judge? Was there any? I'm kind of curious how the court responded to that.
Sure. Well, because there was a lot of media coverage of this case, because of the proximity in time from the judge calling the mother a liar to the kid being killed, there was a lot of media exposure. So the judge did prepare a statement that was read in court when there was a hearing shortly after the murder, and the mother appeared in court It was very scripted, and she didn't feel like it was a very heartfelt apology. Even in that statement, he said, I had no way of knowing that this child was in danger. And yet, I mean, she handed him emails. The father had put up a website about how he was going to kill his child, and she had text messages on her phone. There were, by the way, 3 different judges had denied her protection in the 2 months leading up to the murder of her child. So there was a police officer who heard her story, who looked at all the evidence, who got her a temporary restraining order. But in the end, this is a positive story, and I guess some people feel very pleased that the judge who did make this mistake with this child was challenged by a DA in the election in June, and he was unseated and lost his election. Dr. Phil actually invited his opponent onto the show and invited this judge onto the show to explain exactly what his thinking was and what happened. And the judge didn't appear. His opponent did, but he's on the bench until January of 2011. So that whole community was in an uproar, and they actually had a major protest, and they all came out and raised their voices saying, you know, our kids need to be better protected. And, you know, certainly these cases where the children are dying is absolutely tragic, but for those who are living through these 10-year custody battles, knowing that their kid has to go off for 2 months this summer to be with a parent who has, you know, been convicted of domestic violence or is threatened to hurt the children. I mean, they're living just absolute tragedies. So I would also encourage people who aren't protected parents to be there for people who are, because they're really, really getting out of bed in the morning. I look at all of you who have lived through this, and you're my heroes, because I honestly don't know how you deal with it. And it's not like you go to court, you lose your kids, and it's over. I mean, you get drugged back again and again, year after year, until your child's 18. You can be brought back, and it is incredibly painful, incredibly expensive and devastating, and lots of foreclosures and bankruptcies, and it's sort of this untold epidemic that I think the media is just now beginning to recognize as the problem that it is. And so it is something that I think as we all talk to each other, we can help to be a solution toward. Are there any other comments? Questions? Yeah.
Give someone else a chance. I'm kind of curious. I've been told that guardian ad litems are a cottage industry.
Mm-hmm.
And so I'm curious, when I think of cottage industry, I think of independent, that they're independent. So I'm wondering, why do they have so much protection by the court if they're a cottage industry?
Well, there's a concept and a protection that judges have called judicial immunity. And when GALs and other court appointees were put into place, they were granted essentially quasi-immunity. So a lot of this cottage industry, I mean, they're part of a bigger cottage industry because there are mental health professionals and others who are making money off of these families. GALs are just one of those professions. And there are essentially, especially here in Montana, no guidelines around qualifications. These people don't have to have certain credentials as mental health professionals or domestic violence experts or child abuse experts. And I know tomorrow morning we're doing another talk at 9 a.m. and Betsy will tell you more about that before we leave today. But we are going to be looking at what some other reforms are happening around the country around GALs and developing some guidelines. But unfortunately, even in the states where there are good guidelines like California, because there's no accountability, there's often no complaint process in place for litigants. We know lots of stories of judicial retaliation where someone complains that a mediator or a GAL didn't read their file or isn't familiar with their case, and they end up being punished for complaining about what's happened in their case, or just simply trying to get someone who knows and follows the law to be working in their case. So it's, you know, really a systemic issue in terms of there needs to be accountability. And there's certain, we tried to get a bill passed in California to get rid of immunity for people. I mean, lawyers and mental health professionals who don't work in the courts carry liability insurance. It's part of the cost of doing business. And it is our belief that just because they're working in the courts shouldn't mean that they somehow get this blanket immunity to do whatever they choose. And again, there are good people working in those professions, but when you have a whole system that has zero checks and balances, those that aren't in it for the right reasons, or are making grave mistakes, or are completely unqualified and in over their heads, are giving a bad name to all of those who really are trying to protect kids and who are calling in experts when they're realizing that there's abuse and domestic violence and things that they're not trained and capable of understanding. So, yeah.
So are you saying we should abolish judicial immunity?
No, I'm saying for court appointees that that whole notion of immunity for people who are not judges is questionable, because it is creating a system whereby there is no recourse for litigants who.
One of the GAL chair, Zula, did say that she had judicial immunity.
Mm-hmm. Yeah, and
actually threw it. Oh yeah. Oh yeah.
Right.
And not only do they use it against you when it's on tape and there's evidence, you try to provide the evidence to the judges, and you can't even get the evidence that's in black and white before them. Even though the belief, I believe, all guardians, all people in this system started this because of their best interest of kids, but somewhere it gets away because there is no way to follow through, there is no way to have the oversight. What do you do in a situation like that? I mean, what's the solution? What's some of the solutions we can work towards?
Well,
you know, hopefully tomorrow we'll be looking at some of those solutions after we get a chance to hear a little more from you. But one thing I would offer is, in a system that is so broken, or as broken as it is, and if we measure the brokenness in terms of the human pain that is coming out of this system, I think it's important to really look at the wide array of potential options. Certainly when we've worked on this issue before, we've heard, yes, get rid of judicial immunity. Well, certainly that's going to come with consequences, but I think right now we really have to take a look at all the issues that could potentially help the system and help restore some of those checks and balances. Whether ultimately that's where it goes or not is another matter, but we may just have to entertain those questions and not foreclose on them so early.
right. And there are some assumptions or laws in a lot of states, like shared parenting or the friendly parent standard, which there is sort of this belief that you know, all marriages and all divorces should end up in a 50-50 custody or shared parenting, which is a dangerous precedent when you have 58,000 children a year, and that's a conservative estimate. Children who are being court-ordered into unsupervised contact with the very parents they say are beating, raping, and molesting them. To say that 50-50 is what should be always the case. And there is a caveat when they say that, well, except in cases of abuse. But with the popularity of parental alienation syndrome, as you saw in the film, and as you all, many of you have lived through, parental alienation trumps any sort of investigation of abuse. And so that is, why is that true? Because of the whole nature of parental alienation is to blame the protective parent who's suggesting the child's being abused. And so everything shifts toward blaming that parent, and no investigation is done. And there are huge gaps between CPS and the family courts. So a lot of times CPS will hear that there's a custody battle and they'll close the case and say unsubstantiated or insufficient evidence. The courts will get that report and say, oh, well, they did a thorough investigation and they did not find abuse. So therefore, there was no abuse. And in fact, no one has done a thorough investigation, but each entity believes that the other one will or has. And that's another factor that causes the problem. Yeah.
Hi, my name is Candy Magic Jenkins. I'm quite a spoiler at these events. I am an advocate for families falsely accused of abuse and neglect, and I'm looking forward to being involved in a case with my grandson in the near future. And I want to, right now, claim some protection from retaliation because there are two authorities in this room that will be judging whether I have the right to see my grandson. I think that what we're talking about is systemic corruption here, constitutional violations. And I know after the last 10 years I've been involved with this, I've testified legislatively quite often, and I can be looked up and you can see what I've testified. Right now I'm testifying against Child Protection Services at City Council on Monday nights at 3 minutes at a time. But there's no way to be able to affidavit or write a book as to what I've discovered in this system of abuse. And looking at judicial immunity, I don't think that that is something we should exclude. I don't think that the founding fathers of this nation put into action a Supreme Court of any state or the federal government to make evaluations and decisions that go against parental rights. I believe that there is abuse, and I believe that there is now within the domestic violence industry a lot of what you're talking about has been called parental alienation has now transferred itself into the domestic violence industry. So we have a whole family, human, American problem here. And that some of the parents in this room, parents that I've worked with in families, there is no end result for them. Montana, I believe, with the sincereness of my heart, it has an extremely corrupt judicial system. The CASA system is corrupt. The guardian ad litem system is corrupt. Child Protective Services is at the very peak of it. I think that what we have seen has come out of the Child Protective Services because now divorce case, and I am a divorced mother, in years and years ago, divorce was not made a state compelling interest, and that everything that was said in your movie can be transferred to any kind of family case, no matter what it is, whether it's divorce or not. And I think it's endemic in our society that until the people rise up and realize that they are the power and take that power into their hands, we won't see the end of this. And it is a money system. Last time I checked, to take children out of families was a $95 billion a year business. Stephen Baskerville wrote a book called Taken into Custody. It's an exact, I use it as a reference book, like a textbook. It exactly denotes what's going on in the divorce and custody system. Since the disintegration of our society, we have tons and tons and tons of unmarried couples having children. And since there is no commitment between these couples, they use the child and pull them one way or the other, and then most likely the woman in the case will scream domestic violence, and that's the end of the relationships. But it also, on the other hand, women are abusers too, and they can do a lot of, it's both ways. It's not just one way or another. We have a system that has promoted this, and there is no way to take the authority as an individual citizen of any state and walk into any court and demand anything. I know we have submitted petitions for redress of grievance. Many of the 150 legislators from 2002 to 2007 have stacks of documented evidence about this high on child protection or any kind of.
What would be a solution to everything you're saying on both ways? I agree, but obviously one reason I think that we're all here is to work towards solutions.
Right. Well, let me also put in context how, that quote from Margaret Mead that we had in the film, literally it was 4 or 5 of us who got the California state auditor to come in and audit the family courts, which is the first time that they've ever been audited. And what was that?
When Scott Seacat was the state auditor, we just literally begged him to look into the court system. And he couldn't do it unless there was a government agency.
Right. Well,
requesting
the legislature.
It,
yeah, but the legislature can request an audit of any entity. And we were told early on, no, the auditor won't look at the court system. The courts won't allow it. But we pushed for 17 months, and we met with all the different lawmakers across the Capitol. We briefed them all. We introduced them to parents who had suffered through this. We found a champion who said, I will take this to the Joint Legislative Audit Committee. And we had a hearing, and it was a unanimous vote. Every single Democrat, every single Republican in that committee said, if this is about protecting our children, then absolutely we are going to support an audit of this system. Meanwhile, the court system for 8 months tried to block access to the court records and to the personnel in this audit. And it was only under threat of subpoena by the state auditor that the courts gave access to the auditor, who has constitutional rights to have what they call stand in the shoes authority to look into what were the claims. And basically they were focusing on the use of court appointees, and do family court litigants have redress if there's a court appointee who's biased or who isn't following the law. What recourse do they have? Looking at what kinds of cases are all these various appointees assigned to, and who are the same 4 or 5 people being assigned to all the problematic cases. This was our first chance at getting real data to look at what is going on in the courts. And we've now discovered in recent months that there was a massive shredding of files that went on in the middle of the audit, which is why there was a 9-month delay in the blocking of the audit. So now there are potential criminal investigations about to occur with the FBI and the local district attorney, and the Attorney General has said it's not his purview. But this is, it's a money industry, and it is the way it's been for a long time. And with any kind of a system, that people get comfortable and used to how it's working. And so you will meet resistance as you try to move forward with reform, but every kind of new reform is met with resistance, and it just takes persistence and determination that we are going to turn this around. So that whole audit story is still in progress, and it's yet to be revealed what will come of it. Yeah.
I want to speak up for the low-income people like me, because there is no recourse for low-income people. When you run out of money, that's it, you're done. And that's part of the game, is to deplete people's resources and win through attrition. And that's not being addressed at any level, and it's overwhelming for me. And I know it's overwhelming for a lot of other mothers and fathers who can't even afford to pay for a lawyer to go through courts or to get redress when the decision was poorly made or there was out and out illegal behavior going on.
Right. No, that's a very good point. And no matter how much money you have, you're not, there are a few people that are being well served by the courts, but the vast majority that we hear from are losing their children, are having due process violations, laws are being ignored, and those who don't have resources, you're absolutely right, don't have the ability to file an appeal. And very few family law appeals are ever even taken up, because there is broad discretion that is granted to family court judges at the trial level, at the superior court level. Yeah.
So what do you do if you've been to court, say 3 to 5 years, spent tens of thousands of dollars, court's over, the guardian that still wants his bill is gone, quits, the attorney still wants his 10 to 15,000, still you're back in the same boat, nothing ever really got resolved. You're not going to get 10 to 15,000 out of most Montanas. Employers, employees, they don't make squats compared to Marion County.
Sure.
So what do you do? Just tell them, screw you and file bankruptcy, or what do you do?
Well,
you're not going to get $20,000 out of somebody that makes whatever.
Yeah.
I mean, honestly, our attorney honestly told us, until we spend 10 grand, we're not even gonna see the judge. We spent 10 grand, we still didn't see the freaking judge, had to hire another attorney.
Right.
What are you supposed to do? They still want their money.
Yeah, I'm not an attorney, so I can't give legal advice.
But I mean, most of the people on campus, we know that have problems with this type of situation, that's the
Right.
problem.
Right. Well,
The attorneys still want their money regardless. They still want the money. The judge is demanding you pay them.
Even if they did nothing for you.
Right, no, he ain't done a damn thing.
well, there are complaint processes, and they vary from state to state in terms of their effectiveness.
Can the judge order it and then put you in jail because you didn't pay the bill? Because, you know what I mean? What do we do?
Yes, they can, but they did.
Yeah. Okay.
You know, to me, though, that's where the guardian ad litem system can come in and actually be helpful.
No, he still wants his money too, and now he quit.
But no, what I'm saying though is what we're working toward is to make that system one that really can benefit the kids and the families. I mean, that's our hope. That's what we're really working toward. Well, I think if we don't have a positive attitude about it, we're not. But I mean, that's what we're working on. We're working on positive change. That's many of us have been through the system. None of us have had good experiences, for the most part, who are in this room. But I think that guardian ad litems can really serve a very positive role.
How do we pay the guardian when we don't have the money and he's quit?
Well, but so we're looking at all that. I mean, that's part of what we're going to look at tomorrow too.
Yeah, in the back row there.
I guess this is an offer of gesture of hope. What you would say, when you come to the wall, we don't have any, we don't have any more resources. But you can't take those GAL resources. I mean, I think the effort that is being made here is we are all together right now discussing what can be done. And I think that's an enormous step. That all of these factions have come together and we're working toward change is a huge effort toward making that change for our kids in the state. And if nothing else, we can go away tonight thinking this is an option for us.
It's a beginning.
Yeah. Can you tell me in this little time how the guardian ad litems are appointed?
I probably need to defer to a Missoula. I think there's someone.
Well, they could go rafting with the other parent and then volunteer to be their free guardian ad litem.
Pick this one, he's really good. She's
I think it's best just to say they're appointed by the judge. Currently, the judge has discretion over who to appoint as the guardian. Or Emily?
They're not always appointed by the judge. Some families request them to be in their cases. So you can request or you can have them appointed.
But do you request which guardian you want?
You can request, yes, you can interview the guardians and choose who you want. Okay.
But it's still ultimately ordered by the judge. So whether it's an appointment or a request. Yeah, so parties would agree on.
Question back there.
You also disciplinary panel that you mentioned, or someone mentioned on the film. Are you looking to do that in California?
Yeah, that idea has gotten traction in different places around the country. I know in Rhode Island right now they're working on legislation along those lines. Our state has been bankrupt for a number of years, including when we started our organization 4.5 years ago and wanted to do the judicial performance evaluations, which are now being done in 20 different states around the country. And we were told there's no money for anything new. And I think that's probably the case in Montana from what I've been hearing. So unfortunately with government, a lot of really good solutions and ideas are until we get out of this recession, they exist on paper and they can't be implemented unless you can find a revenue source to do that, and nobody's come up with one yet.
I would like to meet one person who's had a positive experience with the guardian ad litem. One. We've been involved with the guardian ad litem system for 3 years and have met several other people. I've never heard of one positive experience, not one.
Well, I think the parents who end up with custody would probably say they had a good experience.
Yeah. Yes, you do. It's the other me. The experience has been very well.
Let me talk to someone who hasn't spoken yet.
Just as a comment, I've been a guardian ad litem, and I've been the dad's attorney, and I've been the mom's attorney. And I have had some hideous GAL experiences, and I have had some that, looking at the kids, I'm thinking, that turned out really well. I could not have done that because I have an interest in my client, but I also have this mommy thing going on that I have to sleep. I have to see something good for the kids.
Right.
And sometimes you have somebody with smarts, brains to see what's going on and be able to translate it, cares not so much about getting paid, but about a good result for the kids, and can filter out parents nattering and their attorneys nattering.
Yes.
And you get a really good result. And the list, I don't know. I'm thinking people who are more involved in the guardian system can tell you how long is the scroll of names. We have a couple of people who could probably speak to that. And for the low-income parents, there's a tiny coffee can for a little bit of spare change for state funding, to help the guardian eat. And in those cases, it could be, I don't know, 80% of the parents could qualify for that perhaps. And so I don't know where, I'm thinking of these people who spend between them on one case, they're talking about the annual income of the average Joe here in Montana,
Right.
or more.
Right.
Or more. And so we have a not so unique but different limitation on everybody involved in the case. The
Right.
solutions are expensive because the people with the solutions have to eat and pay their rent, just like everybody
Right.
else.
Well, in terms of solutions, because I know a number of you are frustrated, like what are some solutions? And I mean, in some places they're realizing, GALs and people working in the courts, that they don't possess the expertise that they need to deal with these cases. A lot of the research shows 70% of contested custody cases involve domestic violence. And yet a lot of GALs are not domestic violence experts or child abuse experts or child sexual abuse experts. And so there are new collaborative approaches where GALs or CPS will partner with the domestic violence expert or agency, or they'll be calling someone in to consult with them on a case rather than assuming that they have the expertise because they went to an 8-hour class about domestic violence a few years ago. I mean, a lot of these cases are domestic violence and abuse cases, and yet the courts have not, because of the lack of guidelines and the lack of accountability, there are people getting into these professions that are in over their heads, that don't have this expertise, that are missing the real signs of danger for these children. And that's why we're seeing this growing body count around the country, is that this lack of accreditation and lack of oversight is starting to have major repercussions as more and more people who aren't equipped are getting involved in these cases. So that's definitely a solution that is working in some communities, is making sure that GALs aren't trying to do it all when they don't have all of the skills and all of the expertise. Any other comments?
Do you mean anyone can be a guardian ad litem? Anyone?
Well, it varies from state to state, but Montana has one of the least, there are little to no guidelines in existence.
I worked in the emotionally handicapped classroom in Florida. Would that qualify me?
Yeah.
So I just want to thank Kathleen Russell for being here tonight. As is evident, this is a very emotional topic, and I really appreciate everybody coming and participating and listening. There are many people interested in this, and as a legislator, my hope is to bring in all the broad perspectives, because I think it is a very difficult thing to parse out. And so for those of you that are interested in talking more about this, please stay afterwards. I'm happy to answer more questions, and I'm sure Kathleen will as well, and tell you a little bit about our hopes for creating positive change for the future and looking at what we can do to have some solutions that will help the children in these cases and the protective parents as well, find a way to have a voice in the courts. So thanks for everybody for coming.